Let me share my screen. So, as discussed in the last class, I'll be starting with the commercial agreement today. And for the commercial agreement, I have picked distribution agreement for today's class. We'll be discussing about what the distribution agreement is, who are the parties to it, why we require distribution agreements, and then we'll straight away go to the drafting. We'll draft together. We'll discuss the terms. We'll draft together. So I want all of you to participate actively in this. And if anyone has any doubt in between the class, do let me know. You can just unmute yourself and do let me know. Give me a second. I'll share my screen. Paras, can you please confirm if this is visible or not? Okay. So in the last class, we have already discussed about the types of agreements. One was commercial agreement. I told you that commercial, let me just go to that slide once again. We have already discussed that commercial agreements are the agreements which are entered between two business parties for the commercial purposes. The catch over here is for the commercial purposes. It should be for the commercial purposes such as sale of goods, provision of services, and business partnership. So we'll discuss today about the distribution agreement, which is between two parties. An agreement which is legally binding contract between two parties where one is the supplier of goods or services, which is known as the supplier, and the other is the distributor who agrees to sell those goods to the customers, and he is known as the distributor. In this agreement, we discuss about the and delineate the terms and conditions governing their relationship between a distributor and the supplier. Now there are different types of distribution agreement as well. One is exclusive, the other is non-exclusive. Then comes selective distribution agreement and multi-level distribution agreement, and so on. So what is exclusive distribution agreement? Can anyone take a chance and tell me what is what is exclusive distribution agreement? Yes. Anyone? Guys, please participate. Otherwise, it won't be an interesting class. Rajdeep, Shreya, anyone?
If anyone is uncomfortable with the mic, you can write in the chat box also.
Yes, please. Okay, I'll proceed. So, exclusive distribution agreement is the agreement where the supplier appoints one distributor for a specified area to distribute his goods and services. So, that is an exclusive distribution agreement where there is only one distributor specified for a particular area, for a designated territory. Then comes a non-exclusive. Of course, if an exclusive distribution agreement talks about one particular area and one particular distributor, a non-exclusive distribution agreement, on the other hand, talks about multiple distributor who can sell a product of the supplier or his services in the same geographic area or a market segment. There can be n number of distributors who can distribute the same product of the same supplier in that same market. So that is a non-exclusive distribution agreement. Any doubt? Any doubt, class? Getting my point? Exclusive and non-exclusive distribution agreement. It's important to understand the difference between two because accordingly we'll draft the terms. Both of these agreements have different terms. I guess no one is in the mood to talk today.
Ma'am, it's clear.
Okay, thank you. Then comes selective distribution agreement and a multi-level distribution agreement. Now, what is selective distribution agreement? In a selective distribution agreement, the supplier selects a limited number of distributors based on a specific criteria such as their experience, their expertise, or the market reputation. Here, what it is, we'll not be selecting n number of distributors like a non-exclusive distribution agreement. We'll have a selected number of distributors and that will be based on their experience and their criteria. Okay, suppose one person is having expertise in a particular specific area of market. Suppose it's a cosmetic market and one person is having its expertise in sale in that cosmetic market, so we'll appoint that distributor for the cosmetic market of a particular area, and the other person is having expertise in dealing with the grocery market of that area, but that same product can be supplied in a cosmetic market as well and in a grocery market as well. So that other person will be appointed for the grocery. Yes.
ऐसे वाले बचे हुए थे उसकी
Was anyone speaking?
No, ma'am. The person has
Okay,
by mistake.
it's fine. It's fine. So, getting my point, suppose in a particular area, suppose I live at Kalkaji. So, in Kalkaji, there are grocery markets, there are cosmetic markets, there are medical shops. Now, over there, you can find a particular soap in a grocery market as well, in a medical shop as well, and in a cosmetic shop as well. Now, we'll do one thing. Supplier will appoint three different distributors for the same particular geographic area, which is Kalkaji. And then based on their expertise and their experience in dealing with the particular market, they'll appoint one person for dealing with the medical shops, other person for dealing with the grocery shops, third person for dealing with the XYZ shops. Getting my point? So this is selective distribution agreement. Any doubt? Okay, I'll move on to next. Then comes multi-level distribution agreement. In a multi-level distribution agreement, the supplier appoints multi-tiers of distributors, each responsible for distributing the products or services to different levels of distribution chain. Now, this arrangement allows for greater market reach and penetration, but requires a careful management to ensure effective coordination between various levels of distribution. Now, what is multi-level distribution? Suppose I am the supplier. I have entered into an agreement with Paras that Paras will be looking after my Delhi market. I deal worldwide. I appointed Paras to deal with Delhi market. He'll be the distributor in Delhi. Now he will be the person who will be looking after all the markets of Delhi, be that South Delhi, be that North Delhi, be that East Delhi, be that West Delhi, Central Delhi, anything. Now what we'll do, then we'll have a different levels of distribution. One person will be appointed for South Delhi area. The other person will be appointed for North Delhi area. The other person will be appointed for Central Delhi area. Again, then that will be segregated. In South Delhi, this particular area, 500 meters, 500 kilometers will be given to this person. Other 500 kilometers will be given to this person. And all of them will report to the supplier. That is me. So accordingly, we will draft the terms of this agreement, which will have levels of distribution, and the terms in this agreement will be accordingly drafted. So it's very important to understand what exactly are the terms and conditions. We can draft the terms and conditions of a particular agreement based on our purpose. What is our purpose? and who are the parties, and what will be our transaction. Nature of transaction, purpose, and objective are the three important things. Before starting with the drafting, we have to be very clear on this point, that what is the goal, what is the purpose of entering into an agreement, who are the parties, what is the nature of transaction, and how then we can proceed, then how to draft with the terms and conditions. Because slightest change in the nature of the transaction will change our terms and conditions accordingly. No, just a second. Now, what is the relationship between the parties? Relationship between the parties in the distribution agreement, or say any other commercial agreement, is like an independent contractors. Now here the supplier and the distributor will work independently. They'll not be responsible for each other's acts and obligations, but yes, they'll have a principal agent relationship in relation to the customer. Getting my point? Suppose supplier will do its own work of manufacturing things. Distributor will do its own work of selling the goods to the customers. But in case customer raises any objection regarding the goods, then supplier will be the principal and distributor will act as an agent who was authorized only to sell the supplier's products or services. He was not obligated, or he is not responsible for any manufacturing defects. There he'll be serving as an agent who is only taking the products from the principal and selling it to the customers. Getting it? Thereafter comes
Yes.
the distribution of rights and responsibilities. Now, in a distribution agreement, or for say any other commercial agreement or non-commercial agreement, we should be very particular about what are the rights and what are the responsibilities of the parties. Now here, supplier has different set of rights, supplier has different set of responsibilities, which we will definitely draft and see how it goes. And distributor has different set of rights and different set of responsibilities. Thereafter, their relationship is also governed by the payment and the compensation. Somewhere it's, if it's a commercial contract, it's very important to have a definite payment and compensation terms, because that will define our transaction, that will define our relationship, that will define everything, how we will proceed with the sales of this product, how we will hire the distributor for selling of the products. Then comes the terms and termination, which we again discuss in the agreement. Now, why do we need an agreement? We can have this all orally as well. Why there is a need of a particular distribution agreement, and why there is a need of a different agreements, like a non-exclusive, exclusive, a specific, a multi-level. Why there is a need? Now, this answer I need from you guys. I cannot expect you guys to sit quietly and listen. This is not a theoretical class. I told you before as well. Tell me, why do we require an agreement? You all have come here for a contract drafting classes. What's the importance of an agreement?
Ma'am, to avoid confusion and to, if there is any doubt, to seek clarity and to have a proper agreed term that what the parties had resolved to earlier.
Yes, right. Any other person?
Normally, if it is an employment agreement, and the terms of the employment should be clear,
Sorry,
and
Anupin,
there should not.
you're not clear. Yes, come again.
Ma'am, it is. Ma'am, am I audible?
Yes, yes, yes.
Ma'am, saying that if it is an employment agreement, then having a proper laid out agree contract helps us in making sure that the terms are favorable to both of us. The payments and salaries are clearly defined, and the rights and duties are also laid out and known to each other.
Yes, very good. So,
Ma'am,
yes, Ojasvi, yes. Right. Rajdi, for transparency and prevention of exploitation. Okay, exploitation is not the right word, but yes, I get your point. So
And ma'am,
basically, yes,
to give rise to rights and liabilities and for limitation like time duration, all those things.
right. So, first of all, we require an agreement for the clarity purpose so that whatever we have agreed orally, we can have it on a paper in writing and re verify everything that yes, this is what we understood and this is what is being actually agreed. Of course, when we orally agree to something, we can say XYZ terms, but it's better to have it in writing. So first, then to manage the risk so that no risk arises in future. If everything is in writing, everything in a particular defined terms, so we can definitely have a legal right and a legal remedy to that. In distribution agreement, we also do this for the protection of brand, because of course supplier is the one who is manufacturing something. He has the title, he is the owner of the goods. He does not want his title to be misplaced or mismanaged by the distributor. So in that terms as well, for the protection of his brand name, we should always have a distribution agreement. Then lastly, for the compliance and enforcement, of course, in every distribution agreement, whatever agreement we are entering into, I always focus on one thing, especially which is the jurisdiction and the arbitration or the dispute resolution clause, because that is the most important clause for us lawyers. That gives rise to how the risk, if in case there, of course we are drafting an agreement, there will be a dispute and there may be a dispute in future between the parties on any of the terms of the agreement. Now this clause, this particular clause which we'll draft for the dispute resolution, will define how to mitigate that risk, how to help the parties to mitigate that risk without going into the litigation, or to effectively come to the same page, or to effectively have a proper resolution process through negotiation or through arbitration and to avoid litigation. So yes, these are the important factors why we require a distribution agreement. And as I have already discussed, this distribution agreement is commonly used in the industries such as manufacturing, retail, technology, pharmaceuticals, consumer goods, and wherever there is a distribution of goods or services through third party channels is prevalent. It can even be cross border distribution agreements, like we discussed in international contracts. There can be international distribution agreement as well. Distribution agreement where one party, the manufacturer, is sitting in France and we are sitting in India and we are the distributor, he is the supplier and we are distributing. So in that case, we can have an international agreement as well. So this is the theoretical part of distribution agreement. Now we'll go on to the drafting of distribution agreement today. So suppose Vega, everyone must have heard about Vega. Suppose Vega enters into a distribution agreement with XYZ Limited, ABC Limited, to distribute its appliances or the products in, I'll make this Delhi instead of South Delhi, in Delhi region. Now we'll draft a non-exclusive distribution agreement today for the said parties. Let me share my word screen. Yes. So this is how we start an agreement. This is a non-exclusive distribution agreement. First of all, we write a title, non-exclusive distribution agreement. Then we go with the effective. Someone joining right now? Surjit Sarkar. Okay. Surjit, you are too late. I've already discussed about the distribution agreement theoretical part, and now we are moving on to the drafting of the distribution agreement, non-exclusive distribution agreement. Rest you can take from the notes. I'll share it in the group or with the paras post the class. So we start like this. This distribution agreement is executed. Then we'll insert the date. Suppose we are executing it on 12th of May.
Excuse me, ma'am. It's the word
Yes.
what page is not
Yes.
the what page is not visible.
Ojasvi, you're not clear.
Ma'am, I'm saying the what page is not visible to us.
Word is not visible.
No,
Okay,
it's the PPT screen that's there.
just a second. I'll check. I'll check. Is it visible now?
Yes, ma'am.
Yes, ma'am.
Okay. So yes, we start like this with the heading non-exclusive distribution agreement. Then we'll write, insert the effective date and the title. This non-exclusive distribution agreement. Now we define each term like this in an agreement in an inverted commas, and we bold it so that we do not have to repeat this term non-exclusive distribution agreement every time we are using the word agreement. We can just use agreement. This is how it is defined in an agreement. While drafting an agreement, this is how we define a particular word or a phrase. This non-exclusive distribution agreement is executed on this. Suppose we are executing it today, 12th of May. This becomes our effective date. Now comes by and between. We'll write about the parties, that between, by and between, who are the parties to the contract. By and between Vega Industries Limited. Then we'll define the party, a company incorporated under the Companies Act or XYZ, whatever act is it, having its registered office at. And then we'll define this Vega Industries as supplier, hereinafter referred to as supplier, which expression shall, unless repugnant to the context, mean and include its successor and assignees. And this will be our first party. Then by and between Vega and the other party, which is ABC Limited. Again, is a company incorporated under the XYZ laws of India or whatever laws it is incorporated under, and having its registered office at this place, hereinafter referred to as distributor. Again, I have defined this term. Now I'll not use ABC Limited again and again. Instead, I'll use distributor and supplier, which expressions shall, unless repugnant to the context. This is something which we use in all our agreements to define a party, which is a second party. Now, distributor and supplier are individually referred to as party and collectively as parties. For this agreement, the expression I have defined over here, two expressions, which is first is IPR, other is material. Now we can have XYZ, n number of definitions over here. Suppose we are distributing appliances over here. So I can have one definition of what all appliances will be there. So I can have a term like appliances, and then appliances means all the hair straighteners, trimmers, colors, etc., as shall be manufactured and supplied by the supplier to the distributor. So this is how we go about. This is just a clause to explain you guys ki how we define terms. So IPR means intellectual property rights owned or licensed, including copyrights, trademarks, service mark, logo designs, or such other similar rights, whether or not registered. Then comes material. Material means all materials, product information, and or content, including but not limited to images, catalog information, text, video, and graphics in relation to the product. Now, product over here will be our appliances. Getting my point? So this is
Yes,
the introduction and the title. Now we go on to the recital part. So this particular part is known as the recital part, which we have marked in green. This particular is the recital clause. Recital clause is basically a clause where we define who are the parties and why have they decided to enter into this agreement. So here the supplier is inter alia engaged in the business of cosmetics, beauty products, and other related accessories, products, including labeling and packaging thereof. Now, the other party is ABC Limited is engaged in the business of inter alia, the sale of products in and around the areas of Delhi. The supplier is authorized to sell the products as detailed in Annexure A and is desirous of selling the products to ABC Limited. Now, accordingly, the parties now wish to enter into the agreement to set out a detailed terms of the sale and purchase of products for the resale to the end customers by ABC Limited. Getting my point? Now, here what we have done, we have first defined what exactly is supplier doing. Then we have defined what exactly is ABC Limited, that is the distributor doing. So here it should come distributor, the distributor. What exactly is distributor doing and what is the connection between the distributor and the supplier? Now the supplier is someone who is authorized to sell its products to the customers, and he is doing that through ABC Limited, through the distributor. He'll be selling the products to the distributor, and distributor will then sell the products, resell the products to the customers. Getting my point? So this is the crux, this is the brief of why we are entering into this agreement. So this part is called the recital. It's always start with whereas. So there are two ways of writing this. Either we can write whereas in the very beginning and then we can have ABCD, or we can write whereas before each line, whereas the supplier, and then whereas the distributor. So both ways are correct. There's no particular right or wrong way to write this. Whereas the supplier. So either way is correct. You can write either the way I have written right now, or you can adopt the method which was written previously. Whereas accordingly. And in that case, whereas will go from here and here it will come as recital. Getting my point? Any doubt?
no,
Any
ma'am.
doubt? Okay. So now, therefore, in consideration of the mutual covenants, terms and conditions, the understanding set forth in the agreement and other good and valuable so this is something very basic and which we use in each and every agreement. This is something you can copy paste from one or the other agreement, which basically says that we are mutually agreeing to the following terms and conditions, which are set here and below. Just a second, give me a second. So sorry, there was someone at the door. So sorry. So yes, purpose and the objective. Now we are going ahead with actual drafting of the clauses. The first clause will come as purpose and the objective. Now I am writing the clause over here. You guys type the clause in the chat box and I'll see whether you're right or wrong. What should be the purpose of this agreement? Is the answers in the chat box? No one has written their part in the chat box. Purpose is to supply the appliances to distributor on certain paras. Anyone else? The parties in this agreement mutually consent to supply the products of the suppliers to the customers. Okay. Animesh, this clause can be a bit more specific. Okay. So I'll write Animesh, what Animesh has written, and I'll try to change a bit. The parties in this agreement mutually consent to supply the product to the products of the suppliers to the end customers through the distributor. I have missed a line over here. Can anyone tell me what is that line which is most important for the purpose of this agreement? Anyone? Anyone? What is the line that I have missed over here?
Ma'am, we cannot see the paragraph again.
Yes, now can you?
Yes, ma'am.
Yes, please. What is the line or the word which I have missed over here? Getting it?
Yes,
Getting?
ma'am.
Yes. So
Yes, ma'am.
this is something very important which we have to mention over here, that the supplier is not under any obligation or restriction to appoint only the particular distributor as a distributor, and he is free to appoint the other distributors as well for the distribution of the same product or appliance. Getting my point? Because this is a non-exclusive agreement. Now the second clause which comes here is, just a second, is the term. Now what is the term? What do you understand by the term?
Duration.
And the
Yes,
time duration.
yes, time duration. Now give me the clause for the same. Has anyone dropped anything in the chat box? The party shall carry on the business for a duration of, yes, so just we. Anyone else? I'll write or just we's clause also. Guys, please do participate. Otherwise, you will not enjoy this class. The parties shall carry on the business. Instead of business, we should always write the term which we have already defined. The party, this agreement shall remain effective. It's better. The parties agree that this agreement shall remain effective or remain in effect for a duration of dash years or months. The parties hereby also agree that the terms of the said agreement can be extended for the duration post the expiry of the term if mutually agreed between the parties in writing. Getting my point? This is how we draft a term clause. The parties hereby agree that the said agreement shall remain in effect or effective for a term period of 3 years unless terminated prior as per the terms of this agreement. The parties hereby also agree that the terms of the said agreement can be extended for a duration post the expiry of the term if mutually agreed between the parties in writing. Now, first line says that this agreement shall be in effect for 3 years. Now, 3 years is not a lock-in period over here for the reason that I have mentioned this, like unless terminated prior as per the terms of this agreement. Now I'll have a termination clause as well in this, which will define that what shall be the or what may be the events, circumstances in which this agreement can be terminated even prior to 3 years. So 3 years is the limit, is the effective period, but which is not fixed. There may be circumstances, there may be situations in which one of the parties can come forward and say that they want to terminate this agreement prior to the completion of 3 years. Similarly, post the completion of 3 years, if the parties desire to continue this relationship between them, to continue this arrangement between them, they can then mutually agree and have it in writing that they are desirous to continue this relationship and hence they are further extending this agreement for this duration. Getting my point? Any doubt? Anyone? Any doubt?
No, ma'am.
Okay. So then third clause come here. Just give me. Garima, yes, thank you. Then third clause come here is of pricing. Now what is this pricing? Tell me. Yes, Animesh wrote a good clause. I'll write his clause as well over here. This clause is a good one. Now, what is pricing? Anyone?
From the cost at which the distributor will buy the products from the supplier and at the cost at which he will sell the product to the end customers.
Right, right.
Ma'am, will it consider like if there is a breach on legal of the part, like the legal of parties breach the contract? the amount that will be paid, will that be considered as pricing?
Come again, Ojasvi, your voice was not clear.
Ma'am, I'm saying that so if there is a breach by either of the parties, so how they will compensate each other, will that come under pricing?
No. Pricing is basically we are laying down the term that this will be the price on which the distributor will buy the products from the supplier.
Okay, okay,
Yes.
got it.
So now here pricing just, so we are talking about the arrangement between the supplier and the distributor, and this pricing defines the price on which the supplier will sell its products to the distributor, and what will be the margin which it will charge if suppose the products are sold to the customers. What will be the margin which will go to the distributor, and what will be the margin which will go to the supplier? Again, it will start as, so you guys can also type your clauses in the chat box, and I'll see if they are appropriate. Yes. The parties agree to sell the product to the distributor at a rate of rupees itna. In case where the appliance is being sold to the supplier is entitled to 20% of the profit amount. The price has been agreed. Okay, the parties mutually agree on the XYZ price with 10% commission on each pack. Okay. Mitlesh, the parties agree to sell the product to the distributor for appliance in case where. So now, Ojasvi, see, here we are dealing with n number of products. It's not like there's only one product, so we can define a particular rate. So in such agreements, what we do when we enter into a distributor agreement or any other commercial agreement, we have work orders. Have any one of you heard about the work orders? Work orders? Anyone?
No, ma'am.
Okay. So work order is a kind of proposal which one party gives to the other party. Suppose I am the one who will get the products, who will purchase the products from Paras. Okay, Paras is the one manufacturing the products and I'll be getting the products from Paras. So I'll raise a work order. I'll raise my demands to Paris that see, this is my market wants, this is what is the need of the customers. Suppose my market is a small market which will require 20 appliances per week. So I'll raise that work order accordingly. I'll mention in my work order that I'll require 20 straighteners, 10 curlers, XYZ appliances, XYZ trimmers in this duration at this price. If the supplier will agree to that price, he'll give his consent in writing to the distributor that okay, we agree to your purchase order and we are ready to supply the products to you at this price. If not, then they may negotiate on that and can revise the work order. Getting my point?
Yes, ma'am. Got it.
So this is how the commercial market works. We raise the purchase order. Once the parties are on the same page related to the work order, then they proceed further with the delivery of the goods, delivery of the appliances, and then there is this raising of invoices. So I'll give a crux of how this goes in commercial market. There is this purchase order which is raised by one party, other party agrees to the work order. If they are on the same page, work order also has certain terms and conditions. Suppose XYZ will be the delivery timeline, XYZ will be the transport number which will pick up my appliances from your warehouse, everything written in that work order. And then when once the party agree to that work order, then they proceed further according to the terms and conditions of that work order. Suppose in that work order, I have written that I'll purchase 10 of the appliances, 10 of the straighteners from you, and I want that 10 of the straighteners from you by next week. I'll be sending my transport to you to pick up my appliances from your warehouse. And accordingly, the supplier, will then raise the invoice to us, which will be paid by us to the supplier in the given timeline, which will again be incorporated either in the work order or in the agreement. Always, which is preferable, is to have the terms and conditions incorporated both in the work order and the agreement, and they should be in sync with each other. If they are not in sync, then we have a clause in the agreement. We always prefer to include a clause in the agreement which says that in case there is conflict between the clauses of the work order and the agreement will prevail. Okay, getting my point?
Yes, ma'am. Got it.
I guess so. It's only Ojasvi is active right now. Okay. So the distributor shall raise the work order and the supplier shall within a period of not more than 10 days will either accept or reject the work order and shall communicate the same to the distributor. In case the parties have mutually agreed on a price as given in the work order, the supplier shall be obligated to abide by the same and shall deliver the goods to the distributor on the set agreed pricing. Okay. Now here we can have that other clause that in case there is any conflict in terms of the said agreement and the work order, the terms of the said agreement shall prevail. Okay. I'll do the formatting and give you a fresh, I'll share with you a fresh one. Then comes transportation and packaging. Now, who will be responsible for the transportation of the appliances and the packaging of the appliances? Again, this is an important term which should be there in a distributor agreement. So this clause can be the parties or the supplier hereby agrees that it shall be solely responsible for the labeling, packaging, and delivery of goods to the distributor's warehouse within the agreed timeline. Getting my point? Has anyone dropped any clause? Yes. Okay. Okay, let's proceed further. Now comes delivery. In case of delivery,
Excuse me, ma'am.
yes.
Ma'am, in the transportation and packaging clause, can we add one line like if the transportation is delayed by the given time period, so the
Mhm.
order will be rejected or sent back?
Yes, that is what I will be including in the delivery clause.
Okay, okay, ma'am.
Yes. The supplier hereby agrees that the time is essence and the delivery of the appliances goods shall be made within the agreed timeline. In case the supplier fails to deliver the goods within the agreed timeline, the distributor shall have the right to reject the goods or may charge this percent of the invoice amount as a penalty. Okay, so this is just a referral clause. This depends on whose behalf you are drafting a particular clause, or what is the nature of transaction and what your party wants. Okay, this can be, there can be n number of ways to draft this clause. Suppose if I were a supplier, my client was a supplier, and he was the one who asked me to draft this clause. I would have changed this clause in such a way that the agreed timeline is only tentative, and in case of any inadvertent delays in the delivery of product, the distributor hereby agrees to revise the timeline and shall communicate the same to the supplier. Getting my point? Now what I have done, I have made this agreed timeline as tentative, which is favoring the supplier. So you will have to see who your client is and what actually is his favor, what actually can benefit him. Getting my point? Getting my point,
Yes,
guys?
ma'am.
Yes. You should always try to protect the interest of your client. You should always draft a clause according to your client's interest. If your client is a supplier, make this timeline tentative, make this timeline flexible. If your client is a distributor, then see what a distributor will want. Distributor will want the delivery of products on time. If you are a supplier, you want a payment on time, so you can accordingly modify the payment clause to make it restrictive. That suppose the delivery will be made on Tuesday, you will have to make the payments by the end of Friday, by the end of the week. If you are not able to make the payment by the end of the week, then you shall be liable to pay XYZ amount as a penalty. Getting my point? If you are a distributor, you will make the payment clause flexible. You will make the payment clause, you will draft the payment clause in a way that even if there is a delay in the payment, the supplier will communicate the same, supplier will serve a notice, and then we can negotiate on the timelines, and accordingly he'll be given 30 days to further make the payments. Okay, so drafting is something very certain to one party, very particular about how one party requires you to draft, how your clients you want you to draft a clause. You can draft a clause which is mutual, which is not against, which is not biased or one-sided, but always try to protect your party's interest at the first hand. Okay. Other clauses which shall be included in this will be invoicing, title, rejection of products, reps and warranties, and some boilerplate clauses. So what is invoicing? Invoicing shall be the payment clause, that how the payment will be made and to whom the payment will be made, what will be the mode of payment, what will be the timeline for payment, all those things. Title comes for the who shall be the owner, who will be the owner of the products. Now, in this case, who will be the owner of the products? The supplier. The supplier will be the sole owner of the products. Then rejection of the products. What can be the circumstances under which the product will be rejected? Suppose the delivery, there is a delay in delivery, or the products delivered are defective, or what other can be the circumstances in which a delivery can be rejected? The goods are expired. Now, this cannot happen in a case of appliance, but suppose if this was something eatable, then if the goods are, or some cosmetic item, then the goods are expired. The goods are torn. Packaging is not proper. In all these cases, the product can be rejected by the distributor. Then comes representation and warranties. Then comes complaints. In case there is any customer complaint, then the supplier shall be solely liable for the same to the extent such complaint is regarding the manufacturing defect or packaging defect. However, in cases where the customer raises a complaint for delay in delivery of the product, the same shall be solely dealt by the distributor and distributor. Getting my point? Yes, guys. Any doubt?
Ma'am, so in the title of goods,
Mm-hmm.
the one we drafted. So after the goods have been transferred to the distributor, will the seller still have the ownership of the goods?
Yes.
Will the ownership not be transferred? Because in
No,
sales,
no, no, not at all. Not at all. Ownership will always be with the supplier. That is why we are incorporating this title clause. He'll always be the owner of the goods. Suppose XYZ company sells Vega appliances, but owner remains Vega, right? Because he
yes,
is the one having the title, he is the one having the trademark, he is the one having the copyright.
ma'am, but then if we see it from the point of view of sales of goods, once the goods are being transferred, the ownership also shifts to I mean, the one who bought the products.
No, in if that is the case, suppose in this case which we are dealing right now, this is not the case. We are not transferring our title to the other party.
Okay, ma'am.
Therefore, we are responsible for the manufacturing defects. We are responsible for everything. Suppose if there was a case that we have agreed to transfer the title as well to the other party, then we shall not be liable for any of the defects once it has been done, once the sale has been done to that party. Now that party shall be responsible for every complaint, every other thing which happens after a proper delivery, after a completion of delivery. Getting my point? Then terms will be changed accordingly.
Got it, ma'am. I get it. So in sales of goods also, once the title is transferred, the liability also shifts to the other party.
Yes, yes, exactly. Once the
Got it.
title is transferred, the liability of all the things is also transferred to the party.
Yes, ma'am. Got it.
So now it's difficult to complete this agreement in this class. I'll be sharing this with you. We'll be discussing this in the next class if possible. If there will be any doubt, I'll complete this agreement. I'll share this draft with you. I'll incorporate all the clauses. Though I have discussed the major clauses, there are only the boilerplate clauses which are left. So I'll discuss that in the next class. I'll share this document with you probably by the evening or tomorrow. And then if any one of you has any doubt, we can discuss it in the next class. Okay?
Ma'am, like just now we discussed,
Mm-hmm.
ma'am, we will be transferring the ownership rights, but will we be transferring the using rights, user rights? Like if the product is something that can be used by someone else, then
In this case, we are just distributing the products. So customer will be the one using the products.
yes,
The
ma'am.
title will be with the supplier. Distributor is just a chain between the supplier and the customer who will be distributing the products to the customer. That is why we are restricting the liability of the distributor only to the extent that he'll be responsible if in case he delivers the products late to the customer.
Okay, ma'am.
Yes.
Ma'am, is it somewhat like principal agent. It's not totally like principal agent, but then as the distributor is distributing the products on behalf of the seller itself only. So it's somewhat like principal agent only. But then again the liabilities are different because the in principal agent it's not agent won't be saying that if you don't do it by this time I'll not be taking it. But in this case the distributor is not liable, is not responsible to take the product if it is damaged or there is a packaging defect or something.
Oh, Jasvi, can you come again with the last line? Your voice.
Oh, I said that. So in this case, the distributor is rejecting the product if there is some kind of defect in the
Defect.
packaging or something. So
Right.
it is somewhere like principal agent, but not exactly like principal agent.
Yes,
Am I right?
this is a principal agent relationship. As I discussed earlier, they are working independently of each other. There are
Yes.
independent terms related to independent rights, independent liabilities. But in case there is any dispute which is raised against the product, then they are working in a fiduciary relationship where distributor is only an agent of the products of the principal. Getting my point? He is
Right. Right.
not liable for each and every defect in the product. He is only liable for the duties which he was obliged to perform. He is not liable for the defects which were on the part of the principal. Okay?
Yes, ma'am. Got it.
Yes. Any other doubt? Anyone? Any other doubt? Okay. Is there anything particular you want me to discuss in the next class? We'll be discussing this as well. We'll take 15 minutes of the class to wind up this agreement and then we'll proceed on with the non-commercial agreement. Is there anyone who wants, apart from the non-commercial agreement, wants me to take any other topic? No? Okay, so we'll devote 15 to 20 minutes to complete this agreement in the next class. And then we'll switch on to the non-commercial agreement. And please, everyone, please participate. Apart from Animesh, Ojasvi, and few others, Mithlesh and all, no one is responding. So, guys, if you want to learn contract drafting, you have to participate. Also, I'll request you guys, you know the proposition now. If you can draft a short agreement and share it with me, I can review that and I can help you out to draft better clauses. This is your discretion if you want. This is not like a homework I'm giving you all, but I'm just requesting that this will only improve your skills. So you know the proposition, just have these clauses be drafted from your end and I can review that from my end. Okay? Will that work?
Yes, ma'am.
Okay. So I'll see how many of you tries to draft this. I'll share the PPT and this word with Paras and he can share it with you. Okay. So Paras, we can call it a class now.
Thank you, ma'am.
Thank you.
Ma'am, there's a question in the chat box. If you could please take it. It's from
Mohammed
Mohammed Bilal.
Bilal, ma'am, if in an agreement, if one of the clauses missing, like invoice clause, then the enforceable or not? Yes, agreement is enforceable, but if it's suppose it's an invoice clause which is missing, this will definitely give rise to disputes in future, but this will not per se make an agreement non-enforceable.
Okay, ma'am.
Yes.
So, ma'am, I believe there are no other questions. We can end this session. Thank you so much, ma'am, and I look forward to having the next class with you.
Okay, thank you, Sakshi.
Thank you,
Thank you.
ma'am.
If anybody have no any doubt, you can leave the session. Thank you so much. Happy learning.